Hi everyone, this week's dispatch video focuses on attendance at disciplinary hearings and the specific question, what do we do if somebody fails or is unwilling to attend a disciplinary hearing that we've scheduled? So this will cover largely cases of sickness absence, so an employee saying that they're too unwell to attend, but we will also focus on simple refusals or non-communication and non-attendance at hearings. So we look to the ACAS Code of Practice on discipline and grievance procedures for a lot of this, and the non-statutory guide which accompanies that code as well. Paragraph 12 does oblige employers and employees to make every effort to attend a disciplinary hearing, but we are aware that employees often seek to postpone for a number of reasons. This may be because they want time to consider their position, to take professional advice on any allegations, but often we also see sick notes submitted for stress and anxiety following the instigation of disciplinary proceedings. Now, where somebody claims they are unable to attend because of stress, anxiety, or some other health-related reason, we as the employer do have conflicting priorities. We have a duty under the ACAS Code to deal with disciplinary matters promptly and without unreasonable delay. On the other hand, as part of a fair procedure, proceeding in an employee's absence is a risk, and we also owe a duty of care to an employee who may well genuinely be struggling. So, in the case of sickness absence, an employee who has a medical certificate is unfit to attend work, first and foremost. The note will usually be very limited and a box tick to say that the employee is unfit to work. This does not necessarily mean that they are not fit to attend a work-related meeting, because that is not carrying out their duties. So in many cases it will be appropriate, especially if the absence is prolonged, to look at obtaining evidence from either a GP or probably more promptly an occupational health therapist. Specific questions can be asked of the therapist in terms of securing the employee's fitness for work. And I wouldn't frame the questions as bluntly as, do you feel the employee is fit? What I would prefer to do is to say, can you give us any recommendations to ensure the employee's fitness to attend a meeting? That might be longer breaks and regular breaks during any disciplinary hearing. It may be an allowance to provide written representations, longer time to consider the evidence. It may even be bringing a companion which is outside of the statutory right to bring a colleague or trade union representative. Now, on this subject, the DWP's Health and Work Handbook does state, in these circumstances, it's likely that the effects of an unresolved dispute on the employee's mental health may be greater if the proceedings are postponed. An employee may be unfit for work but fit to engage with the management process. The doctor or nurse will have to assess whether attendance is likely to cause serious deterioration in the employee's mental or physical health. So essentially, there should be an appreciation by a medical practitioner, particularly if the cause of the stress is work-related and it's new, so it's in response to the allegations, that delaying matters without a conclusion is likely to just cause further stress and exacerbate the condition. Now, where an employee attends an occupational health meeting, hopefully adjustments can be put in place to ensure that hearing can take place, and we can then move forward with those adjustments. If an employee still refuses to attend in conflict with that medical evidence, or simply doesn't attend without giving good reason, it's usually sensible to make attempts to rearrange that hearing. The non-statutory ACAS guide says that we should try to arrange another hearing if the employee fails to attend through circumstances outside their control, such as illness. If we do proceed in the employee's absence, we should allow the employee to make written representations before we conclude matters. We should warn them in advance that the failure to attend a hearing will result in it going ahead in their absence. And the non-statutory ACAS guide does list a number of considerations to weigh up before taking this step. These include any rules we have in our policies for dealing with a failure to attend meetings, the seriousness of the issue under consideration, the employee's current disciplinary record, work experience, position and length of service, the medical opinion on whether the employee is fit to attend, and how similar cases in the past have been dealt with. Now, in cases of non-attendance where there is no excuse and no sick note, I think it's very easy for us to reschedule a hearing and hear it in their absence if they don't attend. If we have medical evidence to suggest that the employee is fit to attend and we've put adjustments in place as recommended and the employee fails to attend, my view is that it would be appropriate to proceed in most cases. The most difficult scenario is where a medical practitioner states that there is no way of the employee being able to attend at present. They may be fit to in the future. There are no adjustments to suggest, and we need to essentially suspend the disciplinary matter. That does cause difficulty, and it does cause a risk in proceeding with the hearing because that is in contrast with the medical evidence that's being provided. If the absence becomes long-term, we may be in a position where we are flipping the process essentially. So we're moving to an absence management process and keeping that pressure on. One final consideration in these proceedings is sick pay. So many policies now that provide for contractual sick pay will have a provision in which states that we will revert to statutory sick pay in the event that absence starts once an invite to a disciplinary hearing has been given. The difficulty for businesses where employees are on full sick pay during a disciplinary process without limitation is that there is no real incentive to come to the hearing. Being moved on to statutory sick pay, which is around £99 a week, will normally see a very significant reduction in the employee's earnings, and that can add an incentive to return to work and face the music in terms of disciplinary attendance. So I hope that's a useful examination of this area of the ACAS code. If you do need any further advice, please visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.